We will continue with the downward spiral of Elk Horn Coal Corporation as it will file its first attempt at reorganization. As we have previously covered, to try to prevent this event, Consolidation Coal Company had sold its holdings in Wheelwright, Kentucky to Inland Steel Company. This would not be enough to keep the company solvent. By the time we come to this point, Consolidation Coal Company and Elk Horn Coal Corporation had been under the jurisdiction of the Maryland court for 3 years. Come along with us as we walk through the 1935 plan to reorganize the Elk Horn Coal Corporation and the Consolidation Coal Company. All aboard the Kentucky Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine, but it convinces the YouTube algorithm that we need a bigger time machine to reach more people who love history as much as you do. Now, back to our story. The list of creditors and interested parties. First, let's go over all of the interested parties and the creditors that were involved in the reorganization plan. All of the information for this came from the Justa U.S. Law website. Quote, Venerable Badger and Howard and Harry N. Badger, all of Baltimore, Maryland, for Bondholders Protective Committee. Clarence K. Bowie and Daniel B. Leonard of Baltimore, Maryland, for Elk Horn Coal Corporation and Mercantile Trust Corporation, Baltimore, Maryland, trustee. Kenneth B. Johnson of Columbus, Ohio, and Emory H. Niles of Baltimore, Maryland, for Committee of George A. Davison, Glenn S. Pierce, Lucille Greener, and A. H. Thomas. George Washington Williams and Isaac T. Parks, both of Baltimore, Maryland, for Harry R. Roos and Company. George M. Alexander of Fairmont, West Virginia, for West Virginia stockholders. Seams, Boeing, and Seams, Frederick W. Brune, and W. Randall Compton, all of Baltimore, Maryland, for the trustees. Alfred N. Houston of White and Case of New York City, and Charles Markle of Baltimore, Maryland, for Bankers Trust Company of New York. Marbury, Gossel, and Williams, and L. Vernon Miller, all of Baltimore, Maryland, for 4.5% refunding bondholders committee. G. Campbell Beckett of Davis, Polk, Waldwell, Gardner, and Reed of New York City, and Robert Stinson of Baltimore, Maryland, for Guarantee Trust Company of New York, trustee for 5% bondholders. Unquote. The conditions of the filing. The court, under William C. Coleman, District Judge, opens with the following statements. Basically, we will summarize these. 1. The legality based on the proposed reorganization of the Consolidation Coal Company by the creditors should be approved. 2. Can Consolidation Coal Company meet the obligations imposed upon the federal courts under Federal Law Section 77B of the Bankruptcy Act as amended in 1934, 11 U.S.C. number 207? 3. Consolidation Coal Company had been under jurisdiction of the court for 3 years. The date of the filing was June 1932. The court was aware with the many problems that the company was facing, many of which was the extravagance and spending that the previous management did concerning the company's affairs before receivership. This receivership was merged in the proceedings under Section 77B. 4. All requirements concerning the notification of the creditors and stockholders had been met under the law. All creditors had filed a proposed plan which is now before the court. The objections to the reorganization plan. There were objections filed, and all due considerations was taken into account. The primary objection came from the stockholders that owned 40,000 common stock shares in the company. They did not present a plan, but they wanted some stock in the reorganization without having to pay for it. They felt that they were being discriminated against because they were merely given the right to new common stock at $25 a share. The second objection came from the 5% bondholders. They claimed that the reorganization of Consolidation Coal Company under Section 77B of the Bankruptcy Act was unconstitutional, that their lien should not be denied as the current plan provided. So, just to sum this up, believing that the company could become prosperous with the new leadership, the bond shareholders felt that their investment was greater than that of the creditors and insisted that they be paid first. But would the court side with them on this objection? The question of the Constitution. At this point of this trial, the Supreme Court had not yet ruled if Section 77B of the Bankruptcy Act was constitutional. The case of Campbell versus Allegheny Corporation, 7F 2D 947, was still making its way through the circuit courts, which had upheld that it was indeed constitutional. District Judge William C. Coleman ruled that until the Supreme Court ruled, then the current case would proceed under Section 77B. If the Section 77B was deemed unconstitutional, then the reorganization of Consolidation Coal Company would be amended. The attorneys for the bondholders made the argument that since Section 77B had taken effect after the reorganization case was filed and was upheld at the circuit court level, the attorneys further argued that since the Frazier-Lamecque provision and two previous acts were deemed unconstitutional, that there was no similarity between those cases, that the court should rule that there was no need for review at that time. In next week's video, we will cover the ruling on the modification of the case. District Judge William C. Coleman will have the judgment, and we will cover all of the bond and physical assets that Consolidation Coal Company and Elk Horn Coal Company would have after the reorganization. Then later, we will cover the final decision of the court and how it would affect the people of Letcher County, Kentucky. Thank you. We at Kentucky, Tennessee Living would like to thank you for watching our video series on the scandals of the Consolidation Coal Company. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. We thank you for continuing to support Kentucky, Tennessee Living as we are discovering the mysteries in Appalachian history.